There we go. So we're off. There we go. I hope that everybody's able to see my screen. I'm just going to move. So yesterday we started with the structure of the Bill of Rights litigation. We were focusing on three legs, being the procedural leg, the substantive leg, and the remedies stage. So we had a look at application, we had a look at justiciability and jurisdiction. We also had a look at the substantive concepts, interpretation we started off with. Today we complete with limitation as well as remedy, and then we will also have a look at certain key constitutional court rules. I had a look yesterday at the guide just before we start on the rule of avoidance, and I have seen in the guide that it says it's no longer applicable. I think that's a misinterpretation in relation to the guide. And just as a disclaimer, I'm not the biggest fan of the guide. I've picked up a couple of mistakes here and there within the guide. So just before that paragraph, it also says, and I've mentioned it as well, obviously the principle of avoidance, although it is applied in our law, obviously it depends on a relevant case-by-case basis and whether it should be applicable or not. So it's not a hard and fast rule, but in general, it is a rule that is followed and is still followed within our constitutional dispensation, and that's also particularly provided for in relation to transformative constitutionalism, as well as through Section 39 of the Constitution. But be that as it may, let's continue with this evening's lecture. And we are going to start off with limitation, which is part of this substantive stage. So you're now in front of the court. You should know how the courts do interpret these rights. And we had a look yesterday at the importance of Section 39, where the meaning of the right is determined and the scope of the right. And then it is determined whether the challenged law or conduct conflicts with this right. Apologies, I'm just quickly putting my phone on silent. All right. So this is where we'll be kicking off tonight. Let me just start there and not. There we go, that's better. I'm just moving to the applicable slides. All right, so all of you should know by now the limitation clause. Rights are not absolute, so most rights in the Bill of Rights can be limited. And this is provided for in Section 36 of the Constitution. The limitation inquiry basically involves two questions. Is there a law of general application? And then we move over to the proportionality test. So is it reasonable and justifiable in an open and democratic society based on human dignity, equality, and freedom? And to assist us with that proportionality test, we've got those 5 factors that's set out in Section 36. So first of all, a rule of general application. There, the rule of thumb is it is met whenever a rule is accessible, it's precise and not applied arbitrarily or in a way that discriminates unfairly between persons or groups of persons. Obviously, for example, legislation, etc. Bylaws would be a law of general application. It is published in the Government Gazette. It is accessible and it is precise. The proportionality test is more complex. I can hear somebody's mic is on. Do you just mind everybody checking that your mics are muted? Can we just check that everybody's mic's muted? There we go, thank you. Or still not, so just maybe double check, please, if your mic's muted. All right, so the first of these factors that we have a look at is we have a look at the nature of the right. So here the court must assess the importance of a right. a right that is imported to an open and democratic society based on the values underlying the Constitution will carry more weight in the balancing process. The second one is the importance of the purpose of the limitation. Reasonableness requires the limitation of a right to have some purpose, and then justifiably requires that purpose to be one that is worthwhile and important in a constitutional democracy. Where the purpose does not contribute to the values of the Constitution, it cannot be justifiable. Nature and extent of the limitation. The court needs to assess the way in which the limitation affects the rights concerned. The following question should be asked. Is the limitation a serious or relatively minor infringement of the right? The fourth one, the relation between the limitation and its purpose. Here there must be a causal connection between the law and its purpose. And the last one, the less restrictive means to achieve a purpose. The limitation of a right must have benefits that are proportionate to the costs of the limitation. The limitation will not be proportionate if other means which are less damaging to the right could be used to achieve the end. So those are the 5 factors that's basically employed in relation to the limitation test. And the importance of this is to know that rights are not absolute, rights can be limited, and in the event of limitation, these 5 factors are applied. Also in relation to limitation, it's important to take note of demarcations and special limitations. All right. In relation to demarcations and special limitations, demarcations refer to the fact that some rights in the Bill of Rights are already textually qualified by the relevant text of the right itself. For example, if you think about the right to freedom of expression that's provided in Section 16 of the Constitution, it provides that freedom of expression, specifically the rights, does not extend to propaganda for war, incitement of imminent violence, or advocacy of hatred that is based on race, ethnicity, etc. So these specific requirements circumscribe the scope of the right in question. So in other words, if you propagate for war or if you incite imminent violence, you will not be entitled to the protection of the right to freedom of expression provided for in Section 16 of the Constitution. So you can see by the text of the right itself, that right already provides for the right to be limited. Also, an example of another form of limitations is called special limitations, which authorizes the state to make legislation or to engage in an activity which may have an impact on the right in question. For example, if we think about Section 22 of the Constitution that guarantees the right of every citizen to choose their trade, occupation, and profession freely. However, in the next sentence it is said, the practice of a trade, occupation, or profession may be regulated by law. And if we think about the attorney's profession, so we can choose to choose the occupation freely, but we have to comply to certain rules and procedures as set out in our relevant legislation, being the Legal Practices Act. So there's certain things that we cannot do. So an extent already our right is limited to a certain extent as prescribed by specific legislation. The same goes for doctors, etc., and certain occupations which are regulated by legislation. All right. Very important in relation to fundamental rights is the provision of remedies. So what we will be focusing on today is we're going to be focusing on mainly on Section 38 and 172 of the Constitution, because these are the sections in the Constitution that specifically provides for remedies when there is a transgression of constitutional rights, and specifically your fundamental rights. But we're not going to go into the remedies at all in detail, because the remedies that's basically provided for in relation to constitutional infringements are the remedies that's available to any individual in relation to a transgression in relating to the normal legal processes. Year relevant is page 61 of your guide. So I'm just going to go over to your guide to provide you with the references there, or to just indicate to you the importance of the section there. So yeah, you can see we're on page 61 of the guide, and there it goes, and it lists the relevant remedies that's applicable. It provides the list there, and then it provides a short discussion of each. All right, so we're not going to focus in detail. I'm just going to focus on the context of the relevant sections in the Constitution, but these are the relevant remedies that's available and that is applicable. So when we look at the Constitution that provides for remedies, as I've said, the focus is on section 38 and 172. So section 38, we also know that deals with the enforcement of rights and also deals with locus standi, and it basically says anyone listed in this section has the right to approach a competent court alleging that a right in the Bill of Rights has been infringed or threatened, and the court may grant appropriate relief, including a declaration of rights. So this is the section in the Constitution that provides for the relevant relief. So in other words, section 38, by saying appropriate relief, refers basically to that list of remedies. So when your Bill of Rights are infringed or threatened, any remedy which is normally available to a litigant or an applicant in relation to legal recourse is available when there is a constitutional infringement. So that includes a declaration of invalidity, a declaration of rights, your range of interdicts, a mandamus, damages, contempt of court, exclusion of evidence, all your admin law and labor law remedies is available, development of the common law, cost awards, and then also, it's not really a remedy, but a possibility as well as a referral to Chapter 9 institutions. All right. Also very relevant in relation to remedies is section 172 of the Constitution, which is basically a declaration of invalidity. So when deciding a constitutional matter within its power, a court must declare that any law or conduct that is inconsistent with the Constitution is invalid to the extent of its inconsistency. All right, so this is a remedy and it's referred to as a declaration of invalidity. Then it may make an order that is just and equitable, including an order limiting the retrospective effect of the declaration of invalidity. In other words, if, for example, a piece of legislation is declared as being invalid, it would only, in most instances, be invalid as from the date on which the relevant judgment was provided. Or it can suspend the declaration of invalidity for any period and on any conditions to allow the competent authority to correct the defect. So this is very important, because you can think that by providing by providing a declaration of invalidity, you have to control its effect. So you can control its retrospective application, or you can suspend the declaration of invalidity. Now, this often happens when legislation is declared as being invalid. Then in the relevant court order, the court will suspend the declaration of invalidity and provide the legislature with a period of time. It's usually about anything between 12 to 24 months to correct the relevant legislation. If they don't within the relevant time frame that's provided, obviously that declaration would then become into force, and that relevant section or piece of legislation would then be invalid. The court in the interim can obviously provide for interim relief whilst the legislature would have the time to have a relook and to redraft the relevant legislation. So interim relief would be provided for, but this quite often happens, and the reason for that is to respect separation of powers and to allow the legislature to correct the relevant defect or the relevant unconstitutionality in that regard. All right. The rest of the section says the SCA or High Court may make an order of a similar status concerning constitutional validity of an act of Parliament or conduct of the President, but an order has no force unless it's confirmed by the Constitutional Court, and we discussed that yesterday as well. A court which makes an order of constitutional invalidity may grant a temporary interdict or other temporary relief to a party, or may adjourn the proceedings pending a decision of the Constitutional Court on the validity. Right, so interim relief can be provided. Very important to take note of is that the declaration of invalidity is not a discretionary remedy. The court is obliged to declare legislation or a rule of common law invalid if it is unconstitutional. So there's no discretion in providing this remedy. The declaration of invalidity would be provided, but obviously usually in conjunction with controlling its retrospective effect. We also or suspending the declaration of invalidity. In conjunction with limiting the retrospective application and also in suspension, the courts also a lot of the times employ either severance or reading in. Now, severance refer to the fact that law or conduct is declared invalid to the extent of its inconsistency. So particular sections can be declared invalid while the rest remains intact. And obviously, it must be possible to sever the bad from the good, and the remainder should still give effect to the purpose of the law. So with that kept in mind, for example, it would not be a whole piece of legislation that's declared invalid, only the relevant section or subsection that's problematic. And often used in conjunction with severance is reading in. So that is used when the inconsistency is caused by an omission and it is necessary to add the words to cure it. So obviously a word can be read in if that would be sufficient to cure the relevant defect. And then, as I've mentioned before, other forms of relief in relation to Section 38 that refers to sorry, let me just get to Section 38 that refers to appropriate relief, refers to any of the normal remedies being available to a litigant in relation to finding that a constitutional right has been infringed. Interdicts, in certain instances, even constitutional damages, contempt of court, exclusion of evidence, and as I've said there, it is in the guide on page 661 onwards that you can refer to. So that is the content that is the most important and that should be focused on. We are also going to have a look at certain core constitutional court rules that we'll quickly have a look at. The most important constitutional court rules for the purposes of this relevant module, although we're not going to go into them each in equal or focus on them in equal depth, is Rule 10, which provides for amicus curiae, Rule 12 in relation to urgency, Rule 16 confirmation proceedings, Rule 18 direct access, which we spoke about yesterday, Rule 19 and Rule 20, which deals with appeals and the procedure on appeals, and then Rule 31, documents to lodge to canvass factual material. All right. The Constitutional Court rules are available on the Constitutional Court website. So you're more than welcome to go draw those down if you so wish and have a look at them. It's always a good idea to have the court rules handy to have quick reference to them. So, but we're just going to focus on a couple of these specifically today. We'll have a look at amicus curiae. We're going to have a look at confirmation proceedings, and then specifically also the details in relation to appeals. All right. Is everybody still able to see the screen? Everybody still happy with the pace? Am I moving too fast?
Happy with the pace.
Happy with the pace. All right. There we go. All right. So in constitutional cases, and when we litigate before the Constitutional Court, the submissions by amicus curiae are very important. When you have a look at a lot of the Constitutional Court cases, and if you go have a look at the Constitutional Court website, you'll see that lots of those cases, if not most of those cases, have got amicus curiae that participate. And the reason for that is that constitutional disputes have implication and effects beyond the relevant immediate party to this dispute. So interventions by interested parties are permitted in appropriate circumstances. Amicus curiae is regulated by Rule 16 Big A of the Uniform Court Rules, Rule 16 of the Supreme Court of Appeal Rules, and Rule 10 of the Constitutional Court Rules. All of these provisions are very similar, and they all permit intervention by third parties on such terms and conditions as the relevant court would allow. All right. So the Constitutional Court was the first court to bring in such rule, and so all the other rules are more or less based on this Rule 10 of the Constitutional Court rules. Amicus curiae interventions is important as well because they can have significant consequences for the case, and even under very strict conditions and requirements as set out in Section and Rule 31 of the Constitutional Court rules, they may even be permitted to introduce new evidence. All right. The Constitutional Court regards these applications as very important in shaping their thought process. As you can obviously see, as I've just mentioned, that most cases do have amicus curiae intervening. They are only admitted when, and this is in terms of the rule, where written consent has been obtained from all the parties. Where consent has been obtained, and amicus curiae will be admitted upon such terms and conditions and with such rights and privileges as agreed upon between the parties or as directed by the Chief Justice. Number 2, upon application to the Chief Justice. So although the text of the rule suggests that that admission can be sought via two processes, so either via consent by the parties or via permission of the Chief Justice, the court has unequivocally stated in the Basson case that irrespective of consent or no consent obtained, it has the full discretion to allow amicus curiae or not. So usually it is practice, obviously, to write to the relevant parties to inform them of obtain the permission to act as amicus curiae, but that is not a precondition at all. An amicus curiae is admitted on the sole discretion of the court and upon application to the Chief Justice. All right. An application for admission must be made within the time limits prescribed by the directions given or no later than 5 days of the lodging of the respondent's written submissions or after the time for lodging such submissions has expired. Also, a lot of the time, if there's very important constitutional court cases that deals with fundamental rights, the court will quite often also issue directives and specifically invite amicus curiae to participate as well. And it might even direct specific or send invites to specific institutions. For example, if the case deals with gender equality, it might request or invite the Commission for Gender Equality or the South African Human Rights Commission to enter as amicus curiae. So if you plan to enter as an amicus curiae, your application must engage 3 issues. You must describe the interest of the amicus curiae in the proceedings. You must identify the position that will be adopted by the amicus curiae. Very important, you must set out the submissions to be advanced, its relevance, and the amicus curiae's reason for believing that the submissions will be useful to the court. And very important, it has to be different from the submissions of the other parties. So the purpose of the amicus curiae is to assist the court, obviously to come to its conclusion or to make its finding. Its literal interpretation refers to a friend of the court. So it's simply not able to either support the respondents or the applicants' arguments. It has to bring something new and relevant to the court in that regard. The amicus curiae has a right to lodge written argument, provided it does not repeat any matter set forth in the argument of the other parties and raises new contentions which might be useful to the court. The amicus curiae is limited to the record on appeal, and this is important, and this is Rule 31, unless the facts are common cause or otherwise incontrovertible or of an official, scientific, technical, or statistical nature capable of easy verification. And those are the instances where obviously it can tender new evidence to the court, which is not only limited to the record of appeal, but then you follow the strict rules that's set out in Rule 31 of the Concord Rules. The default position is that oral argument will not be presented. However, the court usually invites the amicus curiae to present oral argument to the court. Costs orders may make provision for the payment of costs incurred by or as a result of the intervention of the amicus curiae. Therefore, an amicus curiae may be ordered to pay part of costs, or costs may be awarded in its favor. But again, it's practice of the court to award no costs for or against the amicus curiae. And the main reason for that, and we'll also have a look at the constitutional costs and constitutional litigation in general, is because the court don't want to deter amicus curiae to participate, and obviously to assist the court in reaching its decision in relation to constitutional rights and making important contributions in that regard. All right, so that is amicus curiae, which you'll find in Rule 10 of the court rules. And just a short note as well, in terms of Rule 16A of the Uniform Court Rules, so when you litigate in front of the High Court, and if a constitutional issue is raised in your papers, you have to put up such a notice on a specific notice board at the court, specifically declaring that your case is raising a constitutional issue. And what that acts as is it acts as an invitation for amicus curiae, if they so wish, to participate in the matter. So you are also more than welcome to have a look at Rule 16A of the Uniform Court Rules. So if you have a case, if there's a constitutional issue raised in the case, you have to put up that notice at the court, which basically acts as an invitation for amicus curiae to become involved if they want to. All right. Then yesterday we talked about confirmation proceedings. In terms of Section 1675, we know that when there's a finding of constitutional invalidity, it needs to be sent to the Constitutional Court for confirmation. So I'm just going to have a move over to I just drew down the rules specifically as well. Here's amicus curiae, urgent applications, and then confirmation of an order of constitutional invalidity. So this is what the rule actually says itself. I'm not going to read through the rules in detail. What I also can do is I can just send these extraction of the rules to Zakiswa, and she can distribute it to you if you'd just like to have a look at this, but this is the rule itself. I'm just going to focus on specific aspects of the rule in relation to confirmation proceedings. So Rule 16.1 of the Constitutional Court rule ensures that the Constitutional Court is automatically informed of orders of constitutional invalidity made by all competent courts by stipulating that where an order on constitutional invalidity is made, the registrar of that relevant court must within 15 days of such an order lodge a copy of the order with the registrar of the Constitutional Court. All right. In addition to Rule 16.1, we have Rule 16.4, which says, a party wishing to apply for the confirmation of an order in terms of Section 172D of the Constitution must lodge an application for confirmation with the registrar, a copy with the registrar of the court that made the order. And this must again be done within 15 days of the declaration of invalidity. So it's not only the court, if a party wishes, a party can also send through that confirmation order to the relevant relevant court, but it's not really necessary because Rule 16.1 in any case says that that happens automatically. All right. There was a question in relation to costs and confirmation proceedings. So confirmation proceedings is not the same as an appeal to the Constitutional Court. An application for confirmation is based on the record of the court, a quo. So litigants are not required to present evidence again to the Constitutional Court. The Constitutional Court may, if it wishes to hear argument on a particular issue in confirmation proceedings, request the Minister of Justice and Constitutional Development to appoint counsel to present argument to the court in terms of the Constitutional Court Complementary Act. All right. But also take note, Rule 16.2 sets out the procedure for appealing an order of invalidity to the Constitutional Court. A person or organ of state wishing to appeal against an order of invalidity must lodge a notice of appeal with the registrar of the Constitutional Court and the court which made the order. The appellant is required in the notice of appeal to set forth clearly the grounds on which the appeal is brought, indicating which findings of fact or law are appealed against, and the order it is contended ought to have been made. Right, so that is confirmation proceedings. And how confirmation proceedings work, you follow the steps set out in Rule 16 of the Constitutional Court rules. Then appeals are dealt with in Rule 19, and then the procedure for appeals are specifically dealt with in Rule 20. Again, I'm not going to read those rules word for word for you. I take it that you can do that yourselves. But just a couple of points which I want to raise in relation to these rules is that litigants may appeal to the Constitutional Court from a decision of the SCA or in exceptional circumstances a High Court. So you can, as I've indicated yesterday, appeal from the High Court, skip the Supreme Court of Appeal and go straight to the Constitutional Court. But again, exceptional circumstances has to be, it is again, interest of justice. Litigants may appeal to the Constitutional Court from a decision of the SCA, it's just a repeat, or as I've said, in exceptional circumstances by the High Court. I'll just remove that extra sentence there. And then important, something which I just want to focus on in relation to constitutional litigation is costs. There's two important cases, which is the locus classicus in relation to costs for constitutional cases. The one is BioWatch and the other one is Botma versus Else. So in relation to the BioWatch case, This is specifically in relation to constitutional litigation, which involves the state as a party. So in this case, the Constitutional Court held that where the state is shown to have failed to fulfill its constitutional and statutory obligations, and where private parties are affected, the general rule is that the state should bear the costs of litigants who have been successful against it, and ordinarily there should be no costs order against any private litigant who has become involved. The general rule in constitutional litigation is that each party pays their own costs. And the reason for this is to allow people to vindicate their constitutional rights. The idea there behind it is that you don't want to stifle people giving effect to their fundamental rights by deterring them with the possibility that they can land up with a cost order. And then with relation to private individuals or constitutional litigation between private parties, Botma versus Els, the general principle, as we know, is that costs will follow the result. In exceptional cases, but this is not that exceptional, it's general, the court will make no order as to costs, in particular where a costs order will influence public interest litigation. So as I've just mentioned, the fact that we want people to vindicate their constitutional rights and not have the fear and not have a fear that they might be settled with a cost order if they do lose. All right. So that is the content that I'd like to discuss with you tonight. I received an email requesting me to go through, I think there's some factual case scenarios and the guide towards the end. Now, I quickly read through them this afternoon. And as I've stated before, I'm not the biggest fan of the guide. And myself do not really understand those examples because they're not examples actually of constitutional litigation. They are examples of normal litigation. So if you'd like to, we can work through those examples, but also I'm opening the floor now for any questions or queries you might have in relation to constitutional litigation, the content that we've covered so far, or any questions that you might have in relation to the guide. Please feel free to raise your hands. Bella Cholofelo. Bella, you can unmute your mic. Do you have a question?
Yes, Prof. Good evening and thank you. Prof, I wanted to know, in terms of studying for this module, would the slides be sufficient? Because I've went through the guide and yeah, it's all over the place. I actually don't understand the guide myself. It just confuses me.
Yes, I would really like your input in relation to the guide for those who've gone through the guide, because I found it very confusing. I've litigated constitutional rights. I've taught constitutional and fundamental rights for many years, and the guide is quite foreign to me, and there's certain things that I simply don't agree with in the guide. My feeling is focus on the practical aspects. So yes, I would focus on the relevant slides and I would focus on the relevant practical aspects. So for example, in the guide, and that's where I've made reference to it as well, is I would focus on principles such as direct access, the Constitutional Court's change in jurisdiction that we've done, the remedies that's available, standing, those sort of things is what I think you need to focus on. Remember that in relation to the admission exams, there's no specific section that deals with constitutional litigation as such, or a section that deals with constitutional law. And also that's the guide in the beginning goes on about democracy and separation of powers, which is a bit theoretical, and my feeling is that we should be focusing on more on the practical aspects. So in that regard, I think things like direct access is important to know, that it needs to be in the interest of justice. Those sort of things, I think that is what you need to focus on in terms of the test that you are going to do for lead, if that makes sense. Sikungu, you've got a question?
Hi, Prof. Yes, I do. Thank you. I'm not sure if I'm audible. Hi,
You're
am I
audible. Yes, you are.
Yes, thank you. Thank you for the lesson. And I just have one question around the amici principles. So yeah, I can hear everything else, but I always have this question, and this is something that I get to encounter in the public interest law space. So basically, what happens, Prof, if, let's say, for instance, you are entering as a constitutional matter as an amicus, and then maybe the two parties now agree on an out of court settlement, but then the issues that their agreement is to amend a piece of legislation without public participation. So what happens there? Because my understanding is that if you're an amicus, you don't have a space in the table, in discussions. But then how do you then?
All right, but remember that obviously in relation to settling, I don't think that is a possibility, because an amicus curiae only enters after written submissions have been filed. So basically after heads of argument. So that is when they when you lodge your application, and when they only after the heads of arguments of the applicant and respondent is filed, the amicus curiae will enter and will file its relevant heads of arguments. So it's not going to be the case of the matter being settled. And remember that you won't be able to settle in relation to, for example, in relation to legislation, or because that's not a possibility, because remember the judiciary or parties don't have a say in relation to legislation. That is solely the prerogative of the executive and the legislature and parliament. So they decide, and they are forced to follow the correct processes and procedure in relation to public participation, etc. And just remember those timelines of an amicus curiae as well. So they will only enter after written submissions, basically. So after heads of arguments have been filed, they will be filing their heads of arguments. So obviously they've got the benefit of seeing what is going to be the applicant's arguments, what is going to be the respondent's arguments. And that is what enables them to bring something new to the court and the way in which they can structure their arguments. So they are not siding necessarily with a party, although they can obviously indicate, through their arguments, they might, you could see that they support, but they have to provide independent information to the court that just does not piggyback on the arguments of either the applicant or the respondent. Does that answer your question?
Not really, Prof, but it's fine. But what I wanted to maybe clarify, yes, the applicant may have filed all their papers, but there's just the respondent hasn't. But then for instance, you try to kind of plug the gap with the information that we have as maybe a public interest lawyer, But then what I'm trying to say, then the two parties then enter into an arrangement, to kind of I'm talking about the policies let me be specific, policies for instance, in the education law, policies that are going to affect every learner, every child. I'm talking about now, I'm just going to be out there. For instance, the DBE entering into an out-of-court arrangement with, let me say, a certain union, amending policies that are affecting every learner, in every school. So that's where I'm going. I'm not sure I'm clear enough, but nevertheless, thanks, Prof.
Okay, perfect. But just to follow up, I mean, even with policy creation and regulation creation, it's the prerogative of the executive and not for relevant parties. So you have to go through, it's the executive's prerogative, and parties can't really decide on how policy, etc., should be developed. Is there any further questions that you'd like to raise?
No, thanks, Prof. I'm okay if you were asking me. I'm good, but I'm talking about there is an example in real life. This is what is currently happening. But thanks, I'm not seeking legal advice. This is my own
All right.
battle. Thanks, man. Thanks.
Perfect. Janus, you've got a question?
There we go. Thank you very much, Professor. Yes, just in an instance where, I mean, if we take the famous marijuana case into account, I'm not too certain how the whole case proceeded, where it started and how it officially ended up in the Constitutional Court. But in line with that questioning, how does one, well, firstly, approach the Constitutional Court to say, you know, this specific legislation, I want to see that it is unconstitutional. Where does one serves one papers? Do you serve the executive? Do you just make an application to court and say, who are we supposed to cite as the opposing party? And I mean, how is the process of changing legislation in that sense?
All right. It would be obviously the relevant minister's portfolio that's responsible for that's responsible for the relevant legislation that you'll cite. So you'll be citing the executive as well. So it would be the relevant minister that's, for example, responsible for the relevant legislation. And yes, the marijuana case is a very interesting case, and it had a very long history. Remember, it was the first Prince judgment, and it's a factional, it's in relation to how do you sort of structure a constitutional case or structure. So it was the first one was brought, obviously, as you would know by now, it's Prince that was refused to be admitted as an attorney because he had a criminal record because he used marijuana. He said, it's my right of religion and to smoke marijuana. I only use it for religious purposes. So the legislation that prevents me from using marijuana for recreational use should be declared unconstitutional. The first round, the court said, sorry, you can't, in relation to the right to religion. It's not going to work. The limitation of the right is fair in relation to applying Section 36 of the Constitution. A few years went by, and again an application was brought. Prince was again one of the applicants amongst others, and this time it was based on another right, which is the right to privacy. And in that case, Prince was succeeded in relation to the fact that the relevant legislation contravenes people's right to privacy and to use marijuana for recreational use within their own private space and sphere. So obviously in that regard, that is how, well, with any factual scenario, is that a person will claim that one of his or her fundamental rights are being infringed. The factual scenario is conducive to challenging the relevant legislation, and then obviously you direct it towards the relevant minister that's responsible for that, giving effect, or the relevant portfolio that's responsible for the legislation.
Absolutely. So in a practical example, for instance, I don't have any background in criminal law currently. I only do civil law. But let's say in a case where the accused has a right to appear or to be heard or have his or her day in court, I'm not sure what the holding time is. I think it might be 24 or 48 hours. But let's say in a practical example, with crime being on the uprising, it's impossible to bring each and every single criminal that has been accused to court. And the statute says, all right, you need to be brought before court within 24 hours of being arrested. But let's say that's no longer practical and the justice system or the correctional services are facing a class action lawsuit for prisoners that are being held and not having their day in court. And let's say one brave attorney decides, okay, well, it's time to change it, and they want to change the holding time from, let's say, 48 hours to 72 hours. In that case, it would be the specific person whose rights have been affected or the attorney themselves against then, let's say, the Minister of Correctional Services and so forth in the full citation. I'm not too certain. Would that be a good practical example?
Yes. So obviously the applicant would be the specific individual whose rights have been affected. So you'll look for a client, for example, who's been detained for longer than 48 hours. And then you will challenge the Criminal Procedure Act, for example, or the relevant piece of legislation that provides for that, and state that that specific section is a breach of your constitutional rights because of A, B, and C. But yes, it has to be a specific applicant whose specific rights have been whose rights have been infringed or threatened.
Fantastic. Thank you very much.
It's a pleasure. Another question by Mbali.
Prof, what is the meaning of
Mbali? Just give me a second. There's somebody else's mic that's not muted. All right, Mbali, you can ask your question. Mbali, unmute your mic.
okay,
Good evening, Mbali. Just unmute. If you're struggling, you can just type your question in the chat box as well. Whilst we're waiting for Mbali maybe to type her question, let's just go to Charlie. Charlie Maluleke.
Good evening, Prof. Can you hear me?
I can.
Oh, thank you. My question relates to the amicus as well as local standing. Does the amicus has to satisfy like Section 38, or it's up to the court's discretion when they apply to be admitted as an amicus?
Yes, remember that it's not a party, so it's not an applicant, so it's not going to fall within the category of Section 38. It's totally within the discretion of the court whether to allow an amicus or not. So obviously it would be dependent on the arguments that the amicus plans to bring and what contribution can it bring to the court. So that is what the court will focus on in relation to an amicus.
Okay. So lastly, through the application, this is where the court sees that they will bring like an independent observation on the matter or arguments.
Yes. So as you saw in Rule 10, so they specifically have to state in their application to be admitted as amicus curiae. So what arguments would they bring? What is their focal points? And so through that application, the court would see if it would benefit at all from that amicus curiae intervention or not. And as I've said, a lot of the times in the very big cases where the court itself will extend invitations to specific institutions or NGOs to act as amicus curiae.
Thank you so much, Prof.
It's a pleasure. Mabuza.
Prof, I just want to know in terms of review applications. So suppose that an organ of state failed to take a decision in a matter, on a constitutional matter, and the review application is brought to the Constitutional Court, wherein the Constitutional Court points out as to what decision the organ of state should have taken in terms of regulations, to be specific. Is it possible for the organ of state to just amend the regulations in order to circumvent the decision that it should have taken? And if so, can one have recourse back to the Constitutional Court to declare the new regulations invalid?
Review in relation to regulations that was the process or procedure was not correctly followed.
Correct.
Remember that in admin law and in PAJA, there's only there is specific remedies that's allowed for. So one of them, for example, would be remittal. So if the court, if a decision maker comes to an incorrect decision, mostly the finding in relation to admin law is that that decision would be sent back to the original decision maker to rectify the procedural irregularity in that regard. So would it be a specific procedure that was not followed in relation to the regulations? Because the finding that any court in relation to review would usually make is it would be remitted back to the original decision maker.
Oh, yes, Prof. That's exactly what I'm talking about. So it's remitted back to the organ of state, but now the organ of state, instead of correcting the error, they amend the regulations to make the regulations valid, constitutionally valid, so that they can not implement the initial decision which they should have taken.
No, I don't think that would be a possibility to amend the regulations to circumvent the order. So it has to be remitted, and the relevant decision maker will have to follow the procedure that's set out in those specific regulations. And for example, only after that would they, if there's a shortcoming in the regulations, whatever the case might be, they will have to amend the regulations, but then following the correct process and procedure in relation to amending those regulations. So they can't so they can't preempt it and fix it before they've got to give effect to the order. They've got to give effect to the order and follow the procedure as set out in those regulations.
All right, no, thanks. I'm asking because there is a judgment in that regard, but then there are just rumors that the regulator is threatening to amend the regulations.
Yes, I don't think, it sounds to me that like that would be irregular and not the way. You can amend afterwards, sure, but you'll have to follow as it's set out in the court order.
All right, thank you, Prof.
Sabia Valapi.
Can you hear me?
I can.
Okay, Prof, mine is on amicus curiae, right? I just wanted to know whether is there any certain test that the court uses to determine whether the amicus curiae has the right to an application or should be admitted, or are there any requirement thereof that is used by the court in order to determine whether the party can be joined as an amicus curiae in a matter?
I remember when we had a look at Rule 10, the application has to engage certain issues. So it has to describe the interest of the amicus curiae. It has to identify the position the amicus curiae is adopted, and it has to set out what submissions it would be advancing to the court, and it has to specifically show the court or state to the court how it would be useful to the court and how it would be different from the submission of the other parties. So there are quite strict requirements already in place within the rules itself. So an application for an amicus curiae is quite detailed in itself. So obviously you address these 3 points, obviously supported usually by a founding affidavit. For example, let's say in the case of the South African Human Rights Commission, one of the commissioners itself, for example, would depose to the founding affidavit stating exactly what is the arguments, what can they contribute to the court, and what is the submissions that they would like to advance. So it's quite strict. The requirements are set out clearly in the rule. So maybe in your own time, you can just revert to that rule and have a look at those requirements.
Okay, thank you very much, Prof.
It's a pleasure. Mbali, are you able to speak now? I see your hand is still up.
Yes, Prof, I'm able.
Okay. Yes, Mbali.
Yeah, good evening, Prof and colleagues. Prof, may I have the meaning of amicus curiae?
Yes. So the Latin term, it means friend of the court.
Oh, okay. Thank you, Prof.
It's a pleasure. Mafole Humphrey. Mafole Humphrey.
Hello.
Hi there.
Yes, Prof.
Hi.
Can you hear me?
I can.
Yes. Oh, Prof, my question is regarding the friend of court. Ne?
Mhm.
So I just want to know, is there any case which you know, or maybe, a case which you know where parties argued before the Constitutional Court that they don't want a friend of court to join the proceedings? Or
I don't
thank you.
think that they would necessarily that, or I'm not aware of a specific case in which such, it was argued or heard by the court. Obviously, sometimes they are against, one or two of the parties are against an amicus curiae joining. But again, irrespective of the fact whether the parties are against or for the amicus curiae joining, it is solely within the discretion of the Chief Justice whether to allow that amicus curiae to join or not. So I'm not aware of any specific cases, or I don't have a case reference, but yes, I'm sure there has been instances where the parties have been against the fact that an amicus curiae join, but irrespective of their permission or not, they're able to join.
No, thank you very much.
It's a pleasure. Bila Cholofelo. Bila, just unmute your mic. Bila. Sandile.
Thank you, Prof. My question was a bit answered with the other colleague that's asked you a question now. But I just wanted to also ask, say, for example, you want to make an application as an amicus curiae. Say, for example, this case that is currently happening now for ESCOM government, and that Gordhan is planning to appeal on. So if let's say we want you as a public, you want to join on to, is it possible to join on to sort of not prevent, what's the word I can use? Maybe say prevent that maybe the say Gwede or Praveen or something do not appeal to that case, because obviously it's in the public interest as well for the load shedding that are currently happening. So is it possible that one can use the amicus curiae?
No, you won't be able. There's a distinct difference between an amicus curiae and a party to the litigation, or an individual or an interested organization that would like to join. So no, you won't. And remember that the amicus curiae is not part of the arguments, so it won't be arguing for or against a certain standpoint. It is there to provide. They are there to provide information to the court. So no, you won't be able to, in that instance, in relation to public interest, be able to join as a amicus curiae in that regard.
So it's mainly for supporting for the information.
It's to provide information to the court so that they can reach their decision.
All right. Okay.
Yes.
So sorry, Prof. I just want to jump in there and just try maybe and get something cleared for me.
Mm-hmm.
Doesn't amicus provide a perspective that maybe both sides have actually missed, probably because they do not have as much interest as that particular organization who applies to be amicus on that particular aspect. So they bring all sorts of information, all sorts of research that they've done, or interpretations of the law to actually help the court to see the perspective that is not being brought about by the two sides.
Yes, that is correct. So they are there to sort of as an objective party to bring information before the court. For example, it might be that they have specific statistics on a specific issue. For example, if it's a case on gender-based violence, that they can provide insight into to the court. Or sometimes it is in relation to maybe providing an international perspective or placing international law before the court that maybe is not mentioned in either the applicant or the respondent's case law. So yes, it's there to be of assistance to the court, and that's why I'm saying they are not there to either further either the applicant or respondent's case, but it is to provide information to the court on a point that might have been missed in either of those parties' pleadings. Does that answer your question? I think, Bella, I've answered your question. I see your hand. Is it still up, or do you have another question? I trust and then Sikungu, you've got a question?
Yes, thank you, Prof. A question and also trying to get to what my fellow colleague was asking. I think it's Mr. Sibia, around objections for an amicus to be, what do you call it, to be admitted. I can not necessarily, I'm not sure off the top of my head, I can kind of like send him a few in which some parties had kind of objected to an amicus being admitted, but I'm not certain if they are from I think they High Court mainly, but I wanted to say I can send him those just to have a look if he wasn't interested on that. And the other question that I had, it's around whether the Rule 16A in respect of the High Court now notice is that strict rule, or is it basically just for collegiality purposes? Because in some cases, the applicants or the parties don't really issue that rule, that notice. And interested parties have to like kind of learn through like out of their own. So if it's not, if it is a rule, a strict rule, does that qualify as how do you call it, irregularity or just something along those lines? Just wanted to find out that.
Yes, it is a strict rule. I'm not exactly sure, and I think it would be possibly highlighted as an irregularity, and you will be there might be certain consequences to it. So yes, I remember when I was a CA, I had to go find that notice board and post the Rule 16A notices on when we litigated. So yes, it is a rule that is being enforced. It might also be that people don't know about that notice board, is able to find it to go and have a look at it, what cases are posted there. But yes, you have, when you raise a constitutional issue, you've got to put that Rule 16A notice up. I'm not too sure about exactly what the consequences would be if you don't put it up, but it is a strict rule, and it's just not one that's there for collegiality. Obviously, it is a rule of court.
Okay. All right. Thanks, Prof.
It's a pleasure. Takalani.
Evening, Prof.
Evening.
Yes, thank you. The issue of amicus curiae application must engage 3 issues. I understand the issue number 1, Can you elaborate when you talk about must identify the position to be adopted by the AC? Since you are saying they are not in support or against or something, which position are you referring to?
All right, they must identify the position to be adopted by the amicus curiae. So basically, what is it that they will be, what is it that they will be advocating or bringing to court? Also, 1 and 2 is very much a part of each other. So, for example, describing the interest of the amicus curiae, you'll provide a description of the relevant institution, why it is bringing the relevant application, and the position that would be adopted. So it would be basically, what is it that you will be bringing to court?
Oh, okay.
All right. What is it that you will be focusing on?
Oh, yes, yes. Oh, I thought it's in reference of whether you are supporting or defending. Okay. But it's just a new objective to say
Yes.
we're supporting the
Yes.
human resource. Okay.
Yes.
Thank
That's
you.
correct. It's a pleasure. Another question. Oh, okay, that was Takalani. I'm just quickly going to have a look at the chats. Is there any specific questions that's in the chat? Does the JSC have a role in ensuring that selection of amicus curiae is fair? No, the Judicial Services Commission is just involved in relation to the selection of judges. Amicus curiae would be, it's usually NGO organizations or institutions such as our Chapter 9s a lot of the time are amicus curiae as well. It would depend on the relevant factual scenario, but no, there's no, obviously it is the, to establish whether that amicus curiae's arguments would be relevant would be the relevant Chief Justice of the court or the relevant judge that decides on the matter. Remember that amicus curiae can be lodged in the High Court, Supreme Court of Appeal, and in the Constitutional Court, although they are much more prevalent in the Constitutional Court, but they can be lodged in the higher court and the Supreme Court of Appeal as well. But no, the JSC does not have a role to play there. Takalani, I think I've answered your question. Is that right? Or do you have another question?
No, I'm fine, Prof. I just forgot to unmute.
All right. Tokolo Lebalu.
Oh, hi, Prof. Can you hear me?
I can.
Yes, just a quick question on amicus curiae. So who verifies the validity of the professional's opinion? Prof?
Yes, who verifies the validity of the professional's opinion?
Yes.
It would obviously be the court itself. So the relevant court would consider the application, and then the court would consider the validity of the arguments and whether they are going to be, whether they are going to take account of them or not.
Oh, okay. All right. Thank you. Thank you, Prof.
Pleasure. All right, I'm just going to have a look at the chats. Is there anything else that you guys would like to discuss with me? I'm just quickly going through the chats to see where I am. If a court made a decision in line with the Constitution, but that decision prejudices a bigger population indirectly and protects a minor population directly, how would the court balance the interests? Well, it would depend on the relevant interests that is at stake, what the relevant factional scenario pertains to. But obviously, within our constitutional values of equality, dignity, and fairness. Obviously, the focus is as well as protecting vulnerable members of the community. So it would obviously depend on what the relevant factional scenario is and the balance that the court would have to consider, as well as if it is possibly two competing rights. Then obviously sort of the limitation analysis would also come into play there. The 16A notice I've answered. Can a case that took place within the jurisdiction of the local division be heard in the main division of the High Court? And why is there such a differentiation? I'm not sure exactly what local division you are referring to there in relation to the hierarchy of courts. Renette obviously wants to leave. Can a state organ review its own decision? That's a very admin law question, but yes, they can. There is, but it's quite specific, and the case law that deals with it is quite controversial. But they can, and you're more than welcome to have a look at the admin law and the latest admin law textbook in that regard that would expand on that, but that specifically pertains to administrative law. But yes, a state organ can review their own decisions. Geshma Holdings is, for example, an example of such a decision, but yes, they can review their own decisions. I think Bella Cholofolo, you'll just have to raise your question again. The ones in the guide are not necessarily wrong examples, but they are not really necessarily examples of constitutional litigation. It's litigation in general. I don't see the constitutional points that's being raised there, and most of them, I would say, there's no constitutional point. Your recourse, I think the one was defamation. The other one was an infringement of intellectual property. So your recourse obviously would be through those relevant fields of law and not the Constitution itself. You're more than welcome to any time email me if you've got an issue or an uncertainty in relation to the modules that I've taught. I've shared my email address yesterday. Please feel free to contact me, and I will definitely get back to you. It sometimes feel that judges overreach, but I think it's always a very fine line that it's walked there because of the separation of powers. But obviously, this is what allows, if that's not the case, the executive not necessarily would be held accountable in all instances. So mostly it's a very fine line to walk, especially in our socioeconomic rights cases in relation to treading on the toes of the executive. And in that regard, our socioeconomic, and that's why we've got the reasonableness test or reasonableness requirements in relation to socioeconomic rights cases. But yes, it's an ongoing struggle, and it's an ongoing academic issue as well. But some, yes, still feel that the judiciary has got too much power. But yes, I think our judiciary has been able to obtain their independence to a great extent. But yes, it is an academic debate that is still ongoing. Let's see if there's the final questions. Takalani Mulemu. Takalani, unmute your mic. All right, I'm moving on to Ketiwe.
Hi, Prof. I have a question regarding, once again, a court's decision, right? So, for example, if someone has a duty to report something like fraud and they don't report it because in South Africa, whistleblowers lose their jobs and a lot of them get killed, then they don't do that because they're fearing for their life, right? Would a court consider that as a valid reason for not, for the person not doing what they were supposed to do in the first place?
in relation to labour law or in relation to reporting the relevant crime when there is a duty to do so?
The latter, reporting the relevant crime when there's a duty to do so.
All right. I think, yes, obviously it is a consideration that would be taken into account, but I doubt whether that would reach a litigation stage because obviously the relevant employer or the relevant regulatory authority would obviously have to drag that person to court and say, you should have divulged and you did not. But yes, I think it would be a very valid it would be a valid defense to say, sorry, I didn't, because this would have been the results, A, B, and C. Any further questions or queries? Takalani, last chance. I'll check the chats. If you type, just unmute your mic. Last call for questions. Nzizi, Miyaka.
Hi, Prof.
Hi.
Good evening.
Yes.
Yes, Prof. My question relates to jurisdiction. The jurisdiction of the court. I think they, like, for example, there's a main division and there's a local division. So what happens if maybe a crime or a certain, a certain crime took place within the local division and it be heard in the main division? Like what happened in the case of Meniwa, where the crime happened in Johannesburg, but it was heard in Pretoria in the High Court. So I wanted to hear that if that is having any impact on the jurisdiction. Thank you.
If a crime is committed, well, it would depend then on the general rules of jurisdiction, which I'm not too familiar with in relation to the different courts, and also then I'm not too sure whether you are referring to the High Court or if you're referring to a regional court. But yes, that would be a general jurisdictional question in relation to crimes, and the general rules of jurisdiction would then apply.
So sorry, Prof. I think that question in particular with the case that we are discussing, the Senzo Meyiwa case, that question actually arose at just at the beginning of the case around jurisdiction, and I think the answer was very simple, that South Africa has one high court, so every high court has jurisdiction on a matter, especially if it does not lead to vexatious litigation.
That's how I interpret it as well, and in relation to the High Court as well. If it's a case that should be heard by the High Court, that is where it should be heard. Thank you very much for that input. All right, so I think all the questions have been covered. Am I right? Please unmute your mic if you still have a question. Takalani, I see your hand is still up, but I don't see that you've got a question. So I'm just going to lower your hand. Msizi, your question has been answered. Sikungu.
Yes, Prof. Thank you so much. Mine is not a question. It's just to say thank you for the classes. I just wondered if I have not had a chance to check who's the next professor, or whether you have any other module that you'll be delivering, or I would assume this is the last. These are the only two you are doing. You will be delivering for us, right?
That's correct.
Okay, but anyway, thank you so much. I appreciate that. And I just saw one of the questions from one of our colleagues. He's asking, what's the purpose of amicus if then the organ of states can review their decisions. I'm not sure if Prof can maybe somehow just briefly clarify to the gentleman what's the main
Yes.
purpose of the, yes, thanks.
So an organ of state can obviously review its own actions and processes. But remember that the purpose of an amicus curiae is not necessarily restricted to review only. The purpose of the amicus curiae is to come into any relevant case that raises an important constitutional issue, to assist the court in reaching its decision. So that is the purpose of the amicus curiae. It is to assist the court in reaching its decision, because as I've stated in the beginning, constitutional matters and matters that deals with fundamental rights have got implications not only for the relevant parties, but it might affect a greater range or and have a greater effect than only those relevant parties. And that is why an amicus curiae intervene, to make sure that the court is aware of this, and also to assist it in reaching its decision and bringing any relevant information that it deems fit before the court. All right. Is all the... I take it that all the questions have been addressed, and I just wanted to say thank you for giving me the opportunity over the last 4 nights. I hope that I've addressed everybody's questions, that you were able to learn something. As I've said at the beginning, I have so much respect for students that does the lead evening classes. It's just taken 4 nights of my life, but I must admit it's been more than enough for me in 4 nights. And I wish all of you very well in your lead journey, and then in your admissions journey and the completing of your articles. I'm sure that it will go really well. And very important is to keep in mind your ethics and your ethical character, and to not be that lawyer, that picture of the shark that I had on one of my slides, and to act ethically and reasonably. And yes, success to everybody. My gift to you tonight is an early evening. So I hope that you guys enjoy the early evening tonight, and then I'm sure that as from tomorrow, it's going to be 8:30 again. So have a very, very good evening. Again, you guys have my email address, and I'll just type it in the chats for those who didn't take note of it yesterday. Questions and queries, you are more than welcome to address to me. I think there was one question or query email that I haven't responded to it personally yet, but it is asked that there is certain notes, except certain recordings or notes that's not necessarily linked to me. I'm not sure if it's linked to ethics or CLP, that's available on the site. If they are relevant, obviously you're more than welcome to have a look at it, but I can't vouch for them because I haven't uploaded them. But yes, if you need anything in relation to my content or clarity, more than welcome to get a hold of me. And as I've said before, good luck with your lead journey, and may you all have very successful careers and practices ahead of you. Have a very, very good evening.
Thank you, Prof.
Thank you so much.
It's a pleasure.
Prof. Thank
Have
you,
a
Prof.
good evening, guys.
Thank you, Prof.
Thank you.
Thank you, Prof.
Thank you.
Thank you.
I just want to know where.
Have a great
Thank
evening.
you. It's recorded.
Prof, is there any assignment which